MCLE has asked us to try to give just kind of a brief one-sentence summary of like what would be a good takeaway from each segment of our program. So I just would ask each panelist to just give like a really quick one-sentence takeaway for people to remember if there's only one thing you're going to remember. So I would start, and I think my takeaway would be, that this is really a very special time, and that, if you're interested in these issues, this is a good time to really work on prevention and other approaches to dealing with the monumental problems that we have with sexual assault and sexual harassment in the workplace. And Jen, do you have a very short takeaway as well?
Yeah, maybe sort of related to that, I think it's a really great time to sort of proactively, as a lawyer, as a counsel, to sit down with your employer clients, to so that you have them, and think proactively about what do we want to make this workplace like? How do we want to change the climate? And then go about getting a training in place that does that in an innovative way. With respect to investigations, I would just say know the objective and the scope before you start.
Thank you, Jen. And Bryn, do you have a final takeaway?
Sure. So for the Massachusetts Equal Pay Act, I would say for the employee side, again, just make sure you go read the statute. It really helps create the right questions that you should be asking incoming clients. I also didn't mention this, but I think it will provide for some really interesting discovery issues into what information you should be seeking from employers now evaluating what exactly is a comparable job. For the employer side, again, I would go look at that AGO guidance. I think it has some really useful materials on kind of like a checklist of what you should be looking at and things that could be useful for affirmative defense.
I guess I would have three takeaways if I'm reading the tea leaves of the SJC correctly. One, employers really need to be careful with disability issues. The court has signaled that they're going to take those seriously. Two, employees, particularly public employees, really need to be careful about employers' managerial powers, especially in situations where there are statutes that give them really strong powers and discretion. And then three, the SJC seems to be being careful with public money. So if you're representing public employers or public employees, you should be factoring that into your calculus for, your strategic purposes.
Yeah, I would just say from management side lawyers, I think we can continue to see rollbacks in the regulatory scheme and other pro-employer laws being put into effect, both at the Supreme Court level and within various agencies. And these decisions can have a pretty dramatic impact on our daily practice with regard to the decisions that relate to what you do, so pay attention to the updates and the news.